Hello there, my name is Benjamin and I am from the Coromandel Workers' Council. Today we will be discussing personal grievances, what they are,
when you should consider lodging one.
and what assistance is available to you if you do need to lodge one.
So what is a personal grievance? A personal grievance is a complaint made by an employee against an employer, and it can be made against a current or previous employer. You must raise the personal grievance with your employer within 90 days after the action that led to the personal grievance, or within 90 days after you became aware of the action, whichever is later. You can use the personal grievance process if your employer has fired or dismissed you unfairly, or done something else you think is unjustified, such as unfairly or unreasonably putting you off work or suspending you, giving you a written warning, or demoting you. A personal grievance is also available on certain other grounds, like discrimination and sexual harassment. Other grounds for laying a personal grievance include breaches around hours and shifts, a breach of your rights around agreed hours, availability clauses, cancellation of shifts, or restrictions on taking secondary employment. You can also lodge a personal grievance if you are treated unfairly as a result of lawfully refusing to take on work in certain circumstances. If an employee wants to bring a claim for personal grievance, then you should put this down in writing. This can be either in a letter or an email. In these circumstances, an email is better as there will be a trail of all communications after it has been sent. Plus, you also have the ability to show the date it was sent. And some email applications also allow you to receive a read receipt once the recipient has opened the email. This may be useful in the future in case there are any conflicting opinions on when or if the email was read the same day that it was sent. After sending the letter, the employee may wish to set up a meeting with their employer so that they can discuss the points raised in the letter and seek a resolution together. All communication that an employee sends should be clear and to the point. The easier it is to understand the personal grievance, the easier it will be to resolve. If you decide to communicate the personal grievance verbally, then you will need to be sure to make notes. You may also want to follow up this conversation with your employer with an email. Again, this is just to ensure that there is a trail of communications that can be used in any future mediation should it be required. Detail is important when you are raising a personal grievance, because the details will always determine the outcome. So therefore, the more details that you can remember and write down, the more it will help your case. If the information is incomplete or does not make sense, then it will be hard to be successful in your personal grievance claim. Ultimately, the employee and employer can try to resolve the matter themselves, or they could involve a mediator to help them with the talks. So let's look at mediators and the mediation process. So if an attempt has been made to resolve the matter informally together, but it has not been successful for any reason, then getting a mediator to help with talks is the next thing to consider. The reasons can range from the fact that the grievance is of a personal nature or that there is enough concern from either side that the employment relationship is sufficiently fractured, that trying to resolve the matter in an informal setting is counterproductive. So what is mediation? Mediation is a voluntary meeting between the employer and employee to resolve a dispute. Parties are brought together to exchange positions concerning the issues, with the aim to come to an agreement. The next step after discussing the issues, both parties will often retire to separate rooms and offers will be exchanged through the mediator. The offers will just depend on what outcome is being sought. So for this reason, it can be helpful to attend mediation with your desired outcome in mind, but also with enough of an open mind to work with the other party to reach a conclusion. A mediator's role is to encourage parties to identify the real issues, identify points of agreement between the two parties, help people find a way through their problem that may not seem immediately apparent, help parties to find a resolution that allows both parties to put the issues behind them, provide an assessment of the risks if the problem is not resolved and proceeds further. A mediator may participate in workplace discussion and education activities, regardless of the outcome of any personal grievance reached in mediation. The outcome remains confidential between the employer and the employee. This means that nothing can be shared outside of the mediation process, which in turn also means that whatever occurs during the mediation process cannot be used as evidence in the error or employment court. Of course, the right to confidentiality can be waived. The confidentiality obligations that normally apply to mediation don't apply to collective bargaining. This is because the collective bargaining parties have to report on progress and discuss options with the people they represent, such as union members, executive teams, or board members. The parties should agree how they will share information with the people they represent and others, including the media, as part of their bargaining process agreement. This brings us to the end of another video about your rights in employment. If you have any questions, please get in touch with us. Visit www cwc.org.nz or email totaka@cwc.org.nz or call us on 027 296 5276. Namahi.